25.
Right, Ms. Matebula, you are still under oath.
Yes, Commissioner.
Yes, thank you, Mr. Commissioner. I just want to make the Commissioner aware that we managed to get a copy of the Sagamata agreement. We've made it available to the Secretariat to make copies. Yeah. We are on page 27. We ended at paragraph 88.
Yeah, and just to check, the copies do confirm what Ms. Matebula has said. Is that what you're saying?
Yes, the copy confirms that the agreement was signed by Dr. Machila on the 14th of December, 2017. And I really would like to have a copy because there are some things that I want to point out to the Commission regarding the agreement.
Okay.
You mean you've given us copies and you didn't keep one?
No, we were not. We were given a soft copy of the agreement. That's why we made it available to the Secretariat to make copies. But if I may be allowed, maybe to open it on email and refer to the clauses that I want to bring to the attention of the Commission.
I'm sure you can do that. Couldn't Ms. Matebula carry on in the meantime whilst you...
I've managed to open it, Mr. Commissioner. I'm just waiting for it. I just want to go to the relevant clauses. I will refer to clause 5 of that agreement.
No, then we were talking past each other.
Oh.
We don't have a copy of the agreement yet.
Okay,
but you can read it into the record.
Yes.
Whatever you want to refer to, you can read into the record.
Yes. Clause 5.1 reads as follows. The purchase price is 1,533,881,920 rand. Allocated as follows. 334 million rand in respect of the ordinary shares, 474 million 462,266 rand in respect of the preference shares. Then 5.1.3, 261 million 784,000 387 rand in respect of the company claims. 5.1.4, 466,635,207 rand in respect of the same claims. On the effective date, 5.2, on the effective date, the purchase price shall be discharged by the purchaser allotting and issuing to the seller the purchaser shares credited as fully paid up at a price equal to the offer price. So the purchaser here was supposed to be Sagarmatha, and the seller be the GEPF represented by the PIC. And it is clear from that clause that the amount, and the 1.5 billion that is referred to is the amount that was owed to the PIC.
By what? By IMSA,
Yes,
the independent media.
yes. And the agreement also yes, I'm trying to find a clause dealing with the share price, because it also dealt with the share price, and if I remember correctly, it stated that the share price was 39 rand 62 cents. Yes, that is clause 2.4.16. Clause 2.4.16. It says offer price means 39 rand 62 cents per ordinary share of the purchaser. And the commission will remember that that was the same price at which the shares were offered to the PIC. And the date on which Dr. Machila signed the agreement is on the last page.
Okay.
14 December, I think it was signed by Mr. Twakuzo Hove on the 13th.
Dr. Machila. On the 14th, or the 13th. 13th and the, yeah.
Dan
on the
Machila
14th.
on the 13th, and for Sagarmatha, Mr. Hove on the 14th. If you look at that.
Oh,
last
yeah,
page.
yeah. Actually, I made a mistake. It was signed on the 13th. May I correct my earlier statement that it was signed on the same day? It was on the 13th.
So there was a transaction then. There was a transaction linking Sagarmatha and the independent media, SA and all that.
Yes. And there are copies of emails that I asked the Secretariat to make available to the Commission. I don't know if members of the Commission received copies of those emails. It will be clear from those emails that communication regarding the Sagarmatha transaction began in mid-November 2017 when they were discussing the non-disclosure agreement. And the Commission will recall that according to Mr. Victor Sini, he received an instruction from Mr. Madavo, if I remember correctly, about the same time regarding the IO transaction.
Yeah, I think we can read this. We can have a look at this. Yeah, I think it's fine. I think we can make a move on.
I'm trying to think what numbers can we give as annexures. Can we use these as annexures to the witness's statement?
Mr. Commissioner, I don't know if we can use them as annexures, well, but we can use, because there is reference to that agreement at paragraph 86, we can mark it annexure BM24A.
Yeah, that's fine.
Yes, Ms. Matibulia, you can continue with a statement from paragraph 89.
Okay. Sequence of events which led to my suspension. My encounter with Franz Likubo from Naledi Advisory Services. On the 4th of October 2017, the Office of the CEO arranged a meeting between myself and Mr. Franz Likubo of Naledi Advisory Services. The manner in which the meeting was arranged was strange. The meeting was arranged by the Office of the CEO, so I had prepared for a meeting with the CEO and not anyone else. Although I was not prepared for a meeting with Mr. Likubo, and the manner in which it was arranged in haste by the CEO's office, I cooperated and proceeded with the interview. Mr. Likubo advised me that they were subcontracted by BCX to investigate information leaks within the PIC and would like to understand how information is handled within Company Secretariat. I took them through that process. I am concerned about the testimony of Mr. Likubo, who testified before this commission that when the former CEO found out that he was under police investigation, the investigation's scope, that is Naledi's investigation scope, was extended to provide the CEO with information relating to the police investigation. Executing Naledi's extended scope in terms of reference, I submit, cannot occur or could not have occurred without identifying possible state witnesses, obtaining information about the nature, extent, and location of the evidence they possess in an ongoing criminal investigation, and or placing a potential criminal suspect in possession of information that, given his power over witnesses, enables an obstruction of justice. I have struggled in preparation for this statement to find any binding ethical codes or regulations concerning how forensic investigators should conduct themselves when instructed by persons implicated in wrongdoing, so as not to become instruments of cover-ups, workplace bullying, or intimidation. I am able to testify that in my case, the border between a legitimate application of workplace discipline and harassment of an employee by persons with something to hide has repeatedly been breached. I am also sure that the way I have been dealt with will have a chilling effect on whistleblowers cooperating or thinking of cooperating with authorities in the future. On the 28th of February 2018, I had a meeting with the CEO in his office at 2:45. On the 28th of February 2018, the CEO indicated to me in a meeting in his office that he does not trust me anymore and asked me how long I've been at the PIC. I responded that it was 2.5 years. He proceeded to say that the first 12 months were okay, but he noticed changes in the second 12 months. I was taken aback by what the CEO said, as it was the first time we ever had such a discussion. He raised...
If I may intervene, did he mention what those changes were that he noticed?
No, he didn't. Paragraph 93. He raised the fact that he had not yet signed my balance scorecard for 2017-2018 financial year. I responded that delays in finalizing my balance scorecard were due to the fact that EXCO had decided that the moderation committee should first discuss and finalize the principles applicable to all BSCs for executive heads and senior management before any contract could be concluded, in order to ensure that the BSCs are aligned with the corporate BSC. None of the executive heads BSCs were finalized at that moment. The Human Resource and Remuneration Committee of the board had also requested sight of my BSC to agree on my KPIs before any contract could take place. He indicated that he did not know what I was doing and who I reported to. I responded that I was doing what I had always been doing in the past 2 years since I joined the PIC. I further stated that I would have thought the CEO should have raised these concerns much earlier. On the issue of trust, I expressed my shock that the CEO was only having these discussions with me only now, and I assured him that I was loyal to the PIC and that he should not have any reasons to distrust me. The discussion took me by surprise also because the CEO signed my BSc and recommended a moderated score of 4.26 for 2016-2017 financial year to the board.
If I may stop you there. In the first sentence of that paragraph, you say he indicated that he did not know what you were doing and who you reported to. Who had you been reporting to for the 2.5 years that you had been at the PIC?
I've been reporting to the CEO.
So he said that he did not know who you were reporting to when he knew that you were reporting to him.
Yes.
But surely the implication is from that statement, if it was used in those words, is that he doesn't know who you're reporting to, making the allegation or sarcastic remark that you're reporting to somebody outside of his line of authority. That's the way I would interpret that. If he's asking, he's not asking who else you're reporting to in the PIC. I'm not sure how you would interpret that, Ms. Matebula.
Madam Commissioner, maybe he was making a sarcastic remark, but I was genuinely surprised that he didn't think that, or he didn't know that I was reporting to him all along. Because maybe it was out of ignorance from my side, or there was something that I didn't know at the time that was happening. Yeah. Should I proceed? On the way forward, the CEO indicated that he would schedule a meeting with himself, myself, and HR in due course to discuss the matter. Corridor talk at the time was that I was next in line for suspension, following the suspensions of several others before me. That is Ms. Vuyokazi Menye, Mr. Paul Magula, and Mr. Simpiwe Maisela. It was after this meeting that I had reason to believe that the rumors were true, given the behavior of the CEO towards myself from the beginning of 2018.
Okay. May I intervene? There is a question that I forgot to ask you. Was there ever a time when Dr. Save visited the offices of the PIC?
Yes, I recall there was a time when Dr. Save made a presentation to, which I can't recall is whether it was the IC committee or the FIP committee. They were making a report or a presentation on the performance of the INMSA, which at the time was not performing quite well. So, yeah, to try and present how they were gonna, intervene to ensure that it performs. I can't recall whether it was 2016 or early 2017. I need to check my records. Yeah.
Okay. What intervention was he referring to?
INMSA was not performing. So what normally happens in that instance, the IC or the FIP will then invite, the PMV team will then identify the investments which are not performing. INMSA was one of those. And he was then, the management of INMSA were then required to come and present before the IC or FIP, as I said, I must confirm that, to come and present how they want to turn around the investment. Yeah. Can I proceed?
Did he specifically mention what their intervention would be?
I'm going to have to go and verify my records, but I believe that there was made mention in that meeting of a possible introduction of an IT, I recall they said a Google of Africa of some sort, that they were going to, embark upon. And coming to think of it now, I think that was referring to IO or Sagamatha. Yeah.
Okay, you may proceed at paragraph 97.
Okay. On the 2nd of March 2018, I had a meeting with the CEO and the executive head of HR in the CEO's office. That is Annexure 27, that is the invite to the meeting. I had another meeting with the CEO on the 2nd of March. The CEO briefed Mr. Polwani, the executive head of HR, who was also present, about his meeting of the 28th of February 2018 with me. The CEO indicated that the meeting was to explore alternatives. I assume alternatives to being demoted or dismissed, and requested Mr. Polwani to provide advice on available alternatives. Mr. Polwani requested me to respond to the issues raised by the CEO. Despite my uneasiness, I told Mr. Polwani that I was surprised by what the CEO told me, especially the fact that he said he does not trust me without providing me with reasons why. The CEO stated that he did not want me to deal directly with the board anymore. This really shocked me, and I asked him whether the board is aware of this, and he responded that he will communicate the same to the board. I was surprised how a CEO would have taken such a drastic decision on a matter which required the board without the board having any knowledge on the matter. It ought to be noted that the PIC MOI makes it very clear in paragraph 16 that the appointment of the company secretary is a matter reserved for the board. Section 89(2) of the Companies Act also regulates the removal of the company secretary. Mr. Polwani advised that in situations such as this, there are two alternatives. Firstly, mutual separation or relocation to another position. I indicated that I needed time to think about our discussion, and we agreed to meet on Monday, the 12th of March, when the CEO was back from his traveling. I recall he was traveling that week. I must note that at no time did Mr. Polwani, an HR practitioner, show any curiosity about any substantive reasons the CEO might have had to justify his behavior towards me. Indeed, the CEO presented no reasons at all, except his subjective feelings justifying my removal, and Mr. Polwani appeared content to enable my removal on this scanty basis. On the 5th of March 2018, I had a meeting with Mr. Polwani. On the 5th of March 2018, I had another meeting with Mr. Polwani. Nothing resulted from the meeting with Mr. Polwani, as he did not present any concrete information justifying my removal or make any offer to me. During our brief discussion, he made a comment that if the organization wanted to get rid of an employee, they always do, because they will find something to charge an employee, as no one is clean. He also indicated that he was there to support the executive directors. I felt disempowered as I came to the realization that I could not even rely on an HR to be neutral, fair, and objective when dealing with my matter. We agreed to meet on the 7th of March 2018 for a follow-up meeting, but that meeting never took place. On the 6th of March 2018, that is the day after my meeting with Mr. Polwani, I had a meeting with the head of internal audit, Mr. Nomagoban, who informed me that he was requested by the CEO and Audit and Risk Committee to audit all directors' emoluments. I was surprised, as the audit was not a planned audit. I was not informed why the audit was commissioned. My department has just gone through a planned governance compliance audit, which I have annexed here as Annexure 28. That was conducted shortly before the internal audit was requested to conduct the audit on directors' emoluments. I was not sure why the sudden turn of events, but my thoughts turned to Mr. Polwani's comment that those in power were intent to find fault in what I was doing. I informed my team about the imminent ad hoc audit and requested them to assist internal audit with their work. This despite the pressure I was under at the time. The audit was eventually conducted and finalized, and it's attached as Annexure 29. On the 12th of March 2018, I had a meeting with Dr. Dan and Mr. Polwani. The purpose of the meeting on the 12th of March 2018 was to provide feedback to the CEO regarding my position on the proposed two alternatives presented by HR. That is the mutual separation or to be placed in an alternative position. I highlighted to the CEO that there was no feedback, as I had not been provided with the details of the alternatives for my consideration by HR. The CEO requested HR to urgently provide me with the detail of the two alternatives. So immediately after that meeting, at 3:30, I had a meeting with Mr. Polwani in his office. Mr. Polwani presented to me an alternative. The first alternative He offered me a position of Senior Manager Regulatory in the Legal Governance and Compliance Business Unit. This I rejected outright, as it was tantamount to demotion. For the second alternative, Mr. Polani advised that he will.
So question, were this within the same payment grades, your role in the senior legal advisor?
It's not, Mr. Commissioner, it is not in the same payment grade, but Mr. Polwan did indicate that if I accept the position, I'm not gonna lose my salary, my current salary, which is at a general manager level.
Okay. Yeah. Which is E something, E?
Yeah, I think it's between E. I think upper E.
The upper E4 or something?
Yes, yes.
Okay.
Yeah. And then the second alternative, Mr. Polwan advised that he will do the calculation with respect to the proposed amount for mutual separation. On the 13th of March 2018, I had a meeting with Mr. Magula, who was the executive head of risk at the time. Mr. Polani facilitated this meeting between myself and Mr. Magula, who was the executive head of risk. Mr. Magula informed me that he was suspended for misconduct relating to an alleged non-performance. The charge related to submission of documents to board. He requested me to be a witness on his behalf about the process of submission of documents to the board, which I agreed to do. I eventually testified during Mr. Magula's hearing, who was subsequently dismissed. I believe that my agreeing to testifying during Mr. Magula's disciplinary inquiry might have also contributed to my suspension. I personally did not see anything wrong with me assisting a fellow colleague, especially since my participation was facilitated by HR and as my testimony would deal with process issues and nothing more. On the 13th of March, that is in the afternoon after my meeting with Mr. Magula, I met with Mr. Polwani. Mr. Polwani presented to me two proposed settlements for mutual separation. The first proposal, which is Annexure 30, was payment of 4 months of my total cost to company. And the second proposal, which is Annexure 31, was payment of 6 months. He advised me that this was a no-fault settlement. When he said this, it drove home to me what was happening to me. Without at all being at fault, I was being deprived of a job that at that time I felt I competently performed. I told Mr. Polwan that I could not accept either offer proposed. He asked me how much would be acceptable, and I indicated that my plan was to stay with the PIC for 5 years, and that 5 years would be acceptable. This, Mr. Commissioner, was my way of saying I really just wanted to do my job. All these actions I submit were obvious hallmarks of attempts to cause me so much frustration that I resigned. The CEO's attempts working with Mr. Polwan did not succeed. Cancellation of my monthly meetings with the CEO. The CEO had initiated monthly meetings between myself and his office, which were placed in my calendar. I felt that was a good initiative as it ensured that regular updates and discussions could take place between myself and the CEO. I noticed that towards the end of 2017, these meetings were all cancelled without any prior notice. This struck me as an attempt to sideline and frustrate me. And I've annexed some of those cancellations as Annexure 32. I'm going to now talk about my suspension. On the 17th of April 2018, I had a meeting with the CEO and the executive head of HR in the CEO's office. About a month after I turned down Mr. Polani's offer of a no-fault termination, I was presented with a letter of precautionary suspension for possible misconduct relating to recent leakages and dissemination of confidential documents. That is PIC board minutes and management committee minutes. I still do not understand how the CEO and Mr. Polani could have concluded that I was the one who was responsible for such leakages. I read the letter, Commissioner, which is annexed as Annexure 33, and realized that the letter stated that I was given an opportunity to make representations before a final decision to suspend me was made, which was not the case. I was contrary to the PIC disciplinary policy, specifically paragraph 4.1.4.2a and b, not afforded the opportunity to make any representations. I highlighted that to the CEO and Mr. Polwan and requested that the letter be amended. The letter was amended and I signed. The one that I signed is Annex Chapter 3. I then handed my PIC laptop, cell phone, iPad to Mr. Polwani, who escorted me out of the building. Although I was logically one of the several persons who could have leaked the management minutes and draft PIC board minutes, which were later deleted substantially, I wish to place on record that I'm not the one who did so. I cannot help but connect my being charged with a dismissible offense to my rejecting the erstwhile CEOs and Mr. Polwani's efforts to demote me or separate me from the PIC. Period during my suspension. During my suspension, there were newspaper articles with expanded allegations of impropriety in the PIC, specifically the allegations that the board's minutes of Mlawuzi payment to Pretty Law had been doctored. There were also newspaper articles which painted me in negative light, suggesting that I was responsible for leaking confidential information of the PIC. I need to state categorically that I did not leak any information of the PIC. It was during the same period that a court application was brought by the leader of the UDM, Honorable Bantu Holomisa, making allegations of wrongdoing emanating from James Nuku email and that of Leishola. My interview with Sizwe and Zaluba Gopoda. On the 5th of July 2018, at 2 o'clock, I was instructed by Mr. Polwani to meet with representatives of another forensic investigating team, this time from SNG. It was Mr. Nyatlo, Mr. Sepo Nyatlo, and Mr. Nkosinathi Lote. The proceedings of the interview were recorded. Mr. Nyatlo indicated that SNG was appointed by the PIC to investigate information that was leaked. The investigation entailed a review of laptops. They were provided with my laptop and that of other staff members within the Secretariat. I asked them to address preliminary issues before we proceed with the interview. And this basically, Commissioner, because it was not the first time I was subjected to a forensic audit by the PIC. So I wanted to understand whether there were possible conflict of interest by SNG, whether any statement I made to them will count as disclosures under the Protected Disclosures Act, and the issue of privilege, that is the status of the answers that I may make to them, what will be the status of those answers. I wanted to also understand the powers that they had, who gave them the authority and the timing of their investigation. In my emails, which is annexed as 34 with SNG investigators, I specifically reminded them that as service providers to the PIC, they were ultimately responsible to carry out instructions that were in the interest of the PIC as a whole, and not to further personal interest of whichever executive might have instructed them as audit professionals. This is the theme the Commission may wish to explore in its recommendations. Whether the PIC has been well served by service providers such as attorneys and forensic investigators, whose actions have ultimately served to delay the exposure of wrongdoing at the PIC and persecute those suspected of bringing such to light. An audit of the legal and forensic opinions given and actions taken by lawyers and investigators will reveal whether this flowed from instructions in the interest of the PIC as a whole, or whether due diligence measures would have revealed the likelihood that these instructions were illegitimate. I submit that if we expect PR agencies and auditors to turn down instructions that appear contrary to good governance, HR best practice, the PFMA and other applicable statutes, policies and values, attorneys and forensic investigators should also not be exempt from this expectation as well. SNG also posed written questions to me, giving me unworkably tight timeframes to respond. I actually did reply to their questions to the best of my ability at the time. Following my meeting with SNG, I was served with a notice to appear before a disciplinary hearing. And this is Annex Chapter 36. I'm going to talk about my cooperation with the SAPS. Okay. The Annex Chapter BM 35, apologies. In April 2018, just after my suspension, I received a call from SAPS investigating officer Sergeant Mpulu. I met with Sergeant Mpulu on the 25th of April 2018, who requested me to assist the SAPS with an investigation. It appeared that the SAPS had opened an investigation into the content of the James Nuku email. Notwithstanding its anonymous nature and scurrilous content, it appeared that the crimes alleged therein were deemed credible enough to warrant an investigation. I was asked by the investigating officer to assist in his investigation, which I agreed to do. My role was limited to authenticating the 2 different sets of minutes, which had apparently been made available to the South African police. I considered myself obligated to cooperate with the South African police as an officer of the court. I did not disclose this to the PIC as I took the view that it might jeopardize any investigations being undertaken by the police. My cooperation with the police was in line with the fraud, corruption, and nepotism policy which prevailed at the PIC at the time. My laptop was also seized by the South African police from the PIC to perform an imaging of my laptop as part of their investigations, in particular to authenticate those sets of minutes. My disciplinary inquiry. The PIC elected to...
Yeah, just a question here. When the police are investigating the company or people within the company, is it right for the company to know and the people, the company to know when people are cooperating with the police, such that the legal department of that company can act accordingly and all that? Do you think it's proper sort of to hide or not to tell the company that you are cooperating with the police?
Commissioner, it depends what the police are investigating. If the police are investigating matters of personal nature which does not relate to the company, I don't think the company has the right to know. But if the investigators relate to the PIC as a company, then maybe perhaps the legal department has the right to know in terms of processes. But as I understand it, they were not investigating official issues of the PIC.
So you reckon that they were just looking at the person? They were not looking at the problems within the company?
They were definitely investigating a person.
A person?
Yeah.
Okay.
My disciplinary inquiry. The PIC elected to use outside legal counsel in my hearing and instructed their long-standing firm of attorneys, Edward Nathan Sonnebex, to initiate the PIC's case. This effectively imposed upon me the need to acquire outside legal assistance. To date, the legal fees I have incurred in my case compute to over 750,000, as the case ran to approximately 20 days of appearance, preparation, and argument. I was fortunate enough to be offered funding covering half my legal costs from an NGO that assists whistleblowers called PLAF. Before helping me, PLAF assisted the Nenegate whistleblower and others victimized for disclosures of illicit payments from Eskom and Transnet to Trillion. Their support for me, however, was on the basis that even though I did not rely on a whistleblowing defense in my disciplinary matter, I was being persecuted on suspicion that I was one. I wish to sincerely express my gratitude for their assistance, strategic advice, and invaluable support. I believe that the suspension and disciplinary action taken against me, as well as the associated financial and reputational costs, are part of a general pattern of victimization of employees at the PIC, suspected of having a hand in bringing wrongdoing at the PIC to light. When the former CEO informed me that he no longer trusted me and wanted me out, what I believe was actually being communicated to me is that I was not trusted to keep quiet about irregular occurrences at the PIC, such as what I've outlined above. While I am grateful that the board saw fit to bring an end to the farce of my disciplinary hearing, its guilty verdict and sanction of dismissal passed upon me, I would urge the Commission to consider recommending that I be recompensated for my proven financial losses. The PIC had vast financial resources to throw at victimizing me, and although I'm back at work, I am deep in debt. I wish to make brief submissions on the conduct of my hearing. The point is to show how disciplinary action, coupled with suspension, was used at the PIC as a tool of victimization against persons suspected of being whistleblowers. I would hope that the Commission would consider recommendations to ensure that future legal advice obtained by the PIC on disciplinary matters is obtained from persons and firms untainted by the going-ons here at the PIC the last few years. If my experience is anything to go by, Disciplinary action was undertaken on scanned evidence without proper procedure to either demoralize employees into taking a financial settlement to leave or else to ruin them and their prospective employment opportunities. This cannot be just and equitable, and the present players in the legal and HR spaces at the PIC have proven, in my view, unequal to the task of placing the interests of the PIC as a whole above those of the executives implicated in the wrongdoing. I do acknowledge that an employer has the right to discipline in instances where there is a prima facie case of misconduct. However, individuals in high positions can abuse that power, as was the situation in my case and numerous others who presented before this commission. In terms of the notice to attend a disciplinary inquiry dated the 14th of August 2018, that is Annexure 35, I was charged with allegation 1. It is alleged that you breached your duty
Sorry,
of...
that would need to be BM 36, I would
36.
think.
Yeah. It is alleged that you breached your duty of good faith and confidentiality as an employee and in your position as company secretary of the PIC, in that you caused the distribution and or copying of confidential PIC information. My legal representatives requested to be furnished with full particulars of the charge, as it appeared to be extremely vague in that no details of the charge were set out in the notice. I was forced to enter blindly into the first day of the inquiry after the chairman of the disciplinary hearing refused to grant us a postponement to allow us to prepare thoroughly. I would even go as far as to say that it felt like an ambush throughout the proceedings. As it turned out, there were multiple charges encompassed within the single charge reflected on the notice, as I will set out hereunder. As a result of the charge being wholly devoid of any particularity and totally ambiguous, and in light of the PIC's refusal to provide or answer a request for further particulars before the commencement of the proceedings, it was agreed after I was coerced that the initiator in his opening address will provide the particularity. From his opening address, it then appeared that I was charged with, first, the downloading of a PST folder into an external hard drive, providing Mr. Simpiwe Maisela with special board minutes of the PIC, that I exploited my position as company secretary to obtain extremely sensitive information belonging to the PIC and place this information on insecure platforms. The charge was then formulated in a letter dated 18 September 2018, after the first stage of the hearing set out by the PIC's legal representatives. This will then be Annexure 37, I believe. Yeah. So the letter read, the charge relates, amongst other things, to the following: the leaking of confidential minutes of board meetings to Mr. Simpiwe Maisela, the distribution and dissemination of confidential information belonging to our client, exposing our client to risk and undermining the safety and security of our client's confidential information, placing our client's confidential information on unsecure platforms, and the copying of backup PST. Despite the wide ambit of the charges against me, I was blamed in essence for two things, both of which I denied. The first is that without lawful excuse or authorization, I disseminated the original draft minutes of the board deliberations on the conduct of the former CEO when he prevailed upon Mr. Mlauzi to donate 300,000 to a third party. In the original minutes, as stated above, the board was critical of the CEO's intervention, although it did not formally censure him. The final minutes excised all this criticism. The second charge flowed from the fact that a laptop computer I was assigned had in it PST files that, to my understanding, which was later explained to me, were emails, copied onto an external hard drive, which hard drive was later also accessed by Mr. Simpiwe Maisela. I had indicated from the onset during the hearing that I did not know how to transfer a PST folder, since I have never done so in my life. From the onset of the hearing, Mr. Polwane acknowledged that many other people had access to both the original draft and final minutes. I was advised by my lawyers that any decision to prosecute must be made with prima facie evidence of wrongdoing, not mere speculation. The sum total of the facts laid in evidence against me was that I had access to both versions of the minutes. Clearly, I should not have been charged simply on the basis of the emergence of both sets of minutes because numerous other people also had such access and could have leaked the minutes. The vexatious nature of the charge is also so reflected in the incomplete SNG forensic report. No other evidence linking me to the leak of the original draft minutes were presented. The SNG report, Annexure 38, stated in the conclusion that due to the limited nature of the digital forensic investigation conducted, we cannot conclude whether any of the 14 individuals whose computers were reviewed leaked the information in question or not. PIC should consider additional and more comprehensive investigation as stated in the recommendation. That those running my hearing persisted with the second allegation against me is even more worrying. This is the allegation that I allowed copying of PST files from my computer, which months later ended up on a hard drive used by Mr. Maisela. After running the hearing for several days and the PIC closing its case, it took me to appoint my own IT forensic investigation firm, SINRE, the Digital Forensic Lab. It's also annexed 39, and calling as witnesses the PIC's own IT personnel to discover the elementary fact that the laptop on which the PIC forensic investigators found PST file transfer on the 1st of September 2017 had only been issued to me on the 24th of October 2017. The IT report confirming this aspect is also attached as Annexure 14. At all material times during which the supposed suspect transfer of PST file was made, the laptop was in possession of IT. Any competent and good faith investigation conducted by dispassionate forensic investigators would have discovered this fact. Ethical legal practice would have compelled that this fact should be made known to me. It was withheld from my legal team and I had to pay my own forensic experts tens of thousands of rands to discover the obvious. This is at the risk of reputation that I could not have made the PST file transfer to the suspect digital device as the laptop was not mine or under my control at the time the transfer was made. It should be noted that the content of the PST file that was supposedly transferred from the laptop to the suspected hard drive were never disclosed to me, again confirming that the charge which was proffered against me was purely speculative. No allegation and or proof was put that the contents of the PST files were my emails. In addition to confirming the PST file transfer, the IT forensic report conducted by SINRE also confirmed that they could not establish the user who copied the backup PST file on the 1st of September 2017 before the laptop came into my possession over a month later. In his statement to this commission of inquiry, Mr. Polwan stated that, I quote, background, the genesis of the disciplinary hearing conducted in the PIC emanated from a report that implicated several employees in senior management in acts of misconduct, predicated by a forensic audit commissioned by the PIC. B, a forensic audit commissioned by the PIC, which established the company secretariat, currently on suspension and undergoing a disciplinary hearing, had in her laptop after it was imaged indicating a use of a removable device that contained information and backup files of the emails as per the SNG report. The same device was used and accessed by a senior manager in the IT department. This may indicate that the two employees may have exchanged information for purposes unknown to the PIC. The evidence of Mr. Polwan is devoid of the truth in that firstly, he withheld crucial information to this commission, that the PIC only issued me with a laptop in question on the 24th of October 2017. I was never in possession of the said laptop in the period of September 2017. It surfaced during my disciplinary hearing that the said laptop was purchased by the PIC on the 24th of August 2017 and was stored by IT department until it was handed to me in October 2017. I have no knowledge of whatever email backup operations that were performed on that computer before it was given to me. Mr. Polwan also did not disclose to this commission of inquiry the very crucial fact that the forensic report the PIC commissioned and relied upon to attempt to drive me out of the organization did not find that I committed any misconduct and it was incomplete.
Is there some documentation that indicates you signed for acceptance of the computer on such and such a date?
Yes, so if Commissioner, I just need to, there could be, but the report, the IT report which I referred to in annexure, in annexure, which will be 40, is annexure 39 in the annexure, shows Commissioner that the first time I logged onto that laptop, and this report was performed by PIC internal IT personnel, that I logged on to the to my new laptop on the 24th of, on the 18th of October 2017. So this was performed by PIC IT personnel.
Mr. Commissioner, that will be at page 3C of that annexure.
So, Commissioner, the very same aspect was also confirmed by my own forensic IT company that I had to appoint to confirm the very facts.
The original annexure number is BM39.
Which will now be 40, but it is 39 on the documents.
Yes, Mr. Commissioner.
What page do you find?
That will be page 4 of the annexure, paragraph 3C.
We'll need to just sort out this annexure afterwards, okay?
I will do so. Mr. Commissioner, may I just request to make my page available to the Commission?
Certainly.
It's 3C.
C reads Martin Tienison and Pelo Motolo logged onto the laptop named PTAL Matebula to establish, I suppose that's established the first time that Bongani Matebula logged onto the computer, and the date is 18 October 2017.
That is correct,
That's
Mr.
the
Commissioner.
document you're referring to.
Yes. Her evidence is that she did not use the computer in September 2017 because it had not yet been given to her.
Now, can we take this, or do we make copies of this and give it back to you?
You can take it, Mr. Commissioner.
Thank you. You may proceed.
152, 53. Okay. Mr. Polwani also did not disclose, I'm on paragraph 153, Commissioner. Mr. Polwani also did not disclose that the 2 forensic investigations conducted by the PIC did not investigate the content of the backup PST. If this was done, it was withheld from my lawyers. This crucial aspect was raised by my lawyers during the hearing, but was never considered by the appointed chairperson of the hearing. My lawyers informed me that the case has cost the PIC about 3 million. Yet here I sit, still an employee of the PIC, after this wasteful and disruptive exercise. I am advised by my lawyers that the selected chairperson ignored vital evidence that clearly exonerated me, and yet at the same time drew conclusions based on speculation. At one stage during the course of the hearing, my counsel had to remind the chairperson of the hearing that the PIC was legally represented when he appeared to interfere on behalf of the PIC. The chairperson denied me an opportunity to thoroughly prepare for my hearing when it became clear upon advice from my lawyers that the charge level against me by the PIC lacked particularity. I need to emphasize this, Commissioner, because if I was given the opportunity of full particularity during the opening, I believe that I would have taken the decision much earlier to appoint forensic IT personnel, but we had to go through the hearing, without the fully disclosed particularity, and it was towards the end when we then realized what the actual charge was, that I had to now take it upon myself to say I also need to appoint my own IT forensic investigators, because there were so many crucial issues that I believed were withheld from us during the hearing. Hence, we had to now establish the various aspect of my laptop, of the new laptop having been given to me in October, which the PIC withheld from us from the onset. Yeah. I am also advised of the case law on how the conduct of a supposedly independent disciplinary hearing chairperson can constitute bias is to be found in a case called Surgical Innovations, Pty Limited versus Commission for Conciliation, Mediation and Arbitration and others. I'm not going to give the full citation. The full citation is there in the statement. In this case, the Labour Court made the following adverse factual findings against a chairperson of a disciplinary hearing for conduct in a hearing that closely resembled what I experienced in my own hearing. I'm going to quote, it's on page 55 of the judgment, 45 of the judgment. A study of the record of the disciplinary proceedings gave a strong indication that Hutchinson had in some or other manner been briefed in this matter, and his manner of participation in the proceedings gave an uncomfortable sense of undue involvement. The refusal of the postponement request to just enable the third respondent to properly prepare, in my view, certainly added to this perception. The manner in which Hutchinson chose to intervene in and steer the disciplinary proceedings equally added to this perception of predetermination. I close quote.
Can you just read the first sentence again, please?
The first sentence.
That paragraph of that quotation.
Okay, it says, a study of the record of the disciplinary proceedings gave a strong indication that Hutchinson had in some or other manner been briefed in this matter, and his manner of participation in the proceedings gave an uncomfortable sense of undue involvement.
Just that quotation is not set out fully here.
Oh, okay.
The first sentence in the statement that we have is a study of the, I suppose it might have been in the latest statement.
Mr. Commissioner, may I just point out something? She indicated in the morning that she had added something to, the quotation. That would mean that the statement, the updated statement was not was not made available to the Commission.
Well, to be fair, I must say it was brought to us in the room that we occupy, but since we had read this statement, we didn't, and it was given to us this morning, so we didn't go through that latest statement. Okay. But you say that it has been corrected, now correct in the last version.
Yes.
Okay, thank you.
Mr. Commissioner, incidentally, the chairperson so criticized by the Labour Court in the case that I've outlined above, and the chairperson who ran the PIC's own matter against me is the same person. Throughout my hearing, we tried in vain to ascertain.
Sorry, are you saying the person, or rather the chairperson who is being criticized or who has been criticized in this case, is the same chairperson who chaired
Who
your
was chairing my
disciplinary?
disciplinary hearing? Yes, Commissioner. Throughout my hearing, we tried in vain to ascertain who instructed the PIC's attorneys to continue my hearing. They refused to provide their letter of authorization. In the context of the CEO and the board en masse resignations, it may well have been that the person driving my disciplinary action is actually now implicated in serious misconduct of their own. I believe the attorneys for the PIC should be given an opportunity to explain from whom exactly they took their instructions during the hearing in the context of an incorrect board and an executive in disarray. Surely the responsible thing would have been to allow the work of the commission to complete before proceeding with my disciplinary matter. I note especially that on the executive side, the people who were in charge of my disciplinary inquiry after the resignation of the former CEO, Dr. Majila, have also been implicated in the allegations contained in the anonymous whistleblower emails. That is, the executive head of HR reports to the CFO, who is also implicated in those emails. I note that the former acting CEO, who is the CFO, has recently also been suspended, allegedly for thwarting the work of this commission of inquiry. I also wish to flag in general terms the danger posed to the standing of the legal profession when it becomes associated with enabling the capture of the state institutions. I would urge an audit to be conducted by the Commission of legal instructions given to law firms by the PIC so that a view may be expressed on whether the PIC as a whole has been well served by those earning millions in legal fees. I am fairly confident that an objective evaluation of the conduct of my own hearing will determine that it was run not to discover the truth of the allegations, but to rush a predetermined outcome. Going further, perhaps the time has come, as it is in the auditing profession, to require a rotation of law firms so that personal relationship between long-standing attorneys and executives who are under fire does not cloud the advice the former provides to keep the latter in place. This will also create an atmosphere for legal firms deprived of access to big corporates to have such access. The verdict by the chairman of my hearing.
Just a quick question from my side. We had supply chain management people here, I think one witness, and they said that they do change companies, they don't stay with one company for a long, long time. Are you saying this isn't the case?
Commissioner, I'm speaking from my experience and my observation of how one legal firm has constantly been used by the PIC in all the matters, and that law firm is ENS. ENS was used for all the disciplinary hearings, and if you go back, the legal opinions that were given, it was also ENS. So I'm speaking on that basis. Yeah.
Yes, okay. Sort of within just the human resources matters.
Precisely.
Okay. All right.
The verdict by the chairman of my hearing. The verdict of guilt was handed down on the 13th of March, 2019. It will now become Annexure 41, but it's now in the documents Annexure 40. I will not repeat what I have already said about the uncontested evidence showing that I was not in possession of my laptop at the time the hard drive was mounted to it. IT had control over the laptop. The sanction of the chairman of my hearing. The inevitable sanction of summary dismissal recommendation was issued on the 20th of March 2019. It will be Annexure 42. On the 26th of March 2019, I received a phone call from Mr. Polwan indicating that he is about to email me a letter, which will be Annexure 43. I received the letter which indicated that I was to report for duty on the 27th of March 2019. It appeared as per the letter that the board decided not to uphold the sanction of the chairman of the hearing. I was instead given a final written warning for the acts of misconduct for which I was found guilty by the chairperson. I am profoundly grateful that my disciplinary ordeal has been brought to an end by the board. Having said that, and with respect, I regard the imposition of the final written warning as unwarranted in law and facts. I am considering my legal options on the outcome of the disciplinary hearing and the consequent final written warning. And this I'm doing for the sake of my reputation as a professional person.
If I may intervene, were you given any reason why, instead of being dismissed, you were given a final written warning?
I was not given any reasons. The letter is there, so there were no reasons given. I also don't know what the board could have explored to arrive to that decision.
You may proceed at 168.
On the
Sorry,
27th,
are you saying, did you say anything about a letter?
yes, Commissioner, the
Which
letter that now reinstated me, also indicating that the board decided not to uphold the recommendation of the chairman, but instead they are issuing me with a final written warning.
Yeah, well, it doesn't mean that they didn't uphold the finding of guilt. It's just that the sanction was changed, isn't it?
The sanction was changed, yes.
Yes.
Yeah.
Okay. I suppose the minutes of the board
Will
that did
assist.
that could assist.
The past year has been difficult for me and my family. I have been hospitalized for stress. I have also lost investment to pay forced legal and IT forensic fees. My savings are depleted and I'm indebted to various creditors. My reputation has been impugned even with the final written warning. In spite of this, I remain committed to serving the PIC as company secretary and hopeful that the commission and other good faith role players can set things right for the organization. I wish to reaffirm my complete devotion to the PIC and its stakeholders. Should I proceed?
All right. Forward, two questions. Given that the board got you back into the company, would the company pay back some of the fees that you spent on your legal fight? Do you think so?
The company, as I understand it, the disciplinary code states that if one is to use legal representation, they use that at their own cost. My plea to the commission is that, first of all, my whole disciplinary hearing was unwarranted. It was solely, and I've demonstrated in my statement that it was based on unfounded allegations against myself. Hence, I'm imploring upon the Commission of Inquiry to consider that aspect.
Second question. It seems like you were away, from the PIC for about a year or so, around there. Like, how different is it now? I mean, when you left, there was a lot of issues, and then since then, there's a commission of inquiry. People have come, some have come back. How are you feeling about the PIC? How's the environment currently, from the time you left up until now? Just broadly, just simply and briefly, if you can.
Which, of course, would be your view. Yeah,
Of
because
course,
others
this is-
may think otherwise.
Of course, it is my view, Commissioner. Yes, again, my view. The prior, there was a spirit of fear, in the PIC, but after I came back now, and I don't know whether it's because of the Commission of Inquiry, I feel that employees are much freer, to speak their minds as well. And I think even with the current leadership, the current CEO, I believe, is really trying his best to ensure that there is also full participation. And one of the things, I'm going to give an example now. One of the things that I've observed is prior my suspension, before we could amend the terms of reference, or for instance, the PMC and EXCO, there were clauses in those terms of reference that said that no meeting will have a quorum in the absence of the CEO and the CFO. If both of them were not in the meeting, there was never a quorum, even if the whole EXCO is there. We then changed those things. So what is happening currently right now is that because the PIC is quite is a busy entity, it takes decision on a daily basis. So the current CEO has created a mechanism where you could have an EXCO meeting, or you could have a board meeting. At the same time, you could have a PMC meeting where one of the executives could be chairing that meeting. So I believe that there is, in a way, trying to decentralize, the power, of one particular individual. So that is my observation from a process and investment process point of view.
You can proceed.
Okay. I'm going to talk about the prevailing MOI. Evidence has been presented before this Commission of Inquiry about non-compliance with the provisions of the MOI as it relates to the executive structure at the PIC, which I fully agree with, and implore the Commission to ensure that this is addressed. There is a real extreme agency to address the concentration of power which is vested in the CEO and the CFO in the current executive structure. It is undesirable to have investment, operations, financial, executive, and assurance functions to be all centered around two executives. I must state that attempts were made to amend the MOI in March 2017. The proposed amendment were initiated through a letter from Minister Gordon on dated the 24th of March 2017. It is now Annexure 44, it will be Annexure 45. On the 29th of March 2017, Annexure 45, which will change to 46, the board met to discuss the letter of the minister. Subsequent to the meeting of the 29th of March 2017, a resolution was crafted to the minister to implement the resolution of the board, and specifically to the directive of the minister. Now, it is the resolution is Annexure 47 now. The revised MOI was filed with the CIPC on the 30th of March 2017 and endorsed on the 19th of April 2017, and Annexure 48 will talk about that. And then we also then received later on, I need to indicate, Commissioner, that at the time Minister Gordon wrote the letter to the PIC, just after that was the time when there were changes at National Treasury, and Minister Gigaba was appointed. Then we received a letter from Minister Gigaba dated the 19th of April. The letter, I just want maybe to read it for the record. The letter from Mr. Gigaba was regarding the amendments to the MOI of the PIC. It reads, it's dated the 19th of April 2017. It says, I have been advised by the CIPC, I have been advised that the CIPC has approved the amendments on the MOI as per the board resolutions of 30th of March, resulting in the PIC having a new MOI. Kindly ensure that this MOI is not effected and agently refile the old MOI with the CIPC for approval, which will remain in existence until I have acquainted myself with the PIC and be in position to make an informed decision on any amendments to the old MOI. I must say, Commissioner, that some of the amendments related to the structural issues, the fact that now it was taking away the position of CIO, COO, and CRO. And hence I was saying there were attempts during my time to change those as well. But then,
So-
based on the instruction from Minister Gigabo, we had to now refile the old MOI. So we are now back with the old MOI, which now, in terms of structure, also requires the PIC to have a CIO, COO, and CRO. Yeah. It should be noted as well that prior to those above mentioned processes which I have, there was a legal opinion that was sought on these aspects. Then I'm gonna, it's Annexure 50, it will change to Annexure 51. I'm gonna talk about employee instability. I set out here
Can I
under-
just ask something? But I'm not sure whether you might have an answer, but do you know that the CIO position across the board is no longer a big position generally,
It's no longer?
globally? The CIO position is no longer as big as it was like 10 years ago and all that. Do you know that?
No, I do not know that.
I'm just saying global asset managers and locally here, that position is no longer as big as it was.
I
You
do
don't know
not
that?
kn- I do not know that, Mr. Commissioner.
Okay,
Yeah.
all right,
Mm.
okay.
My,
okay.
my basis is only based on the PIC and the fact that the PIC is an asset manager. Yeah, I don't know the global trends on that. Yeah. Employee instability. I set out here under how the company experienced functional instability, causing instability among staff members, and will use my own experience as an example. The resignation of Ms. Petra Decker. After the resignation of Ms. Decker in 2016, the former executive head of corporate services, the functions of corporate plan and records management were added to my department without additional human resources accompanying the function. During an EXCO meeting of 2017, the function to do the corporate plan was then removed from the company secretary to the executive assistant in the office of the CE. It is common practice for functions to be moved from one department to another without following a sound transitional procedure. This was, in my view, exacerbated by the lack of a proper succession plan at the time. The board decided during the strategic session held in October 2017 that the function of records management cannot be performed by the office of the company secretariat to ensure that the company secretary devotes attention to the functioning of the board and not perform management function. Appointment of PIC representative to investee companies. The PIC makes recommendations to nominate and or appoint non-executive directors to investee companies in certain investments. This function was performed by the company secretariat team until the former CEO, through an EXCO resolution, took a decision to remove the function from the company secretariat and move it to a position which he had included in the organizational structure of executive head of investment management. I personally was not averse to such an EXCO decision. However, this was done without proper governance processes and lack of communication with relevant stakeholders, especially the investee companies themselves and the board. Some investee companies continue to communicate with the company secretariat department despite my request that the investee companies be informed of the changes. The appointment of the PIC non-executive directors into the boards of investee companies may have oversight merits. However, this practice poses a potential or perceived conflict of interest which needs to be reassessed. The conflict of interest which applies is not only conflict in terms of the Companies Act, but also conflict in terms of the FACE Act. The interest of the investee company and the client has to be balanced, but certainly aligned as well. The concept of checks and balances has to apply. One remedy to cure this will be to appoint a mixture of internal and external candidates.
Sorry, when you arrived at the PIC, what system was used with the appointment of representatives on investee companies? Was it the CEO who decided on it, or was it
Or
someone
you mean
else?
the process? Okay, so in terms of the process, Mr. Commissioner, it was the appointment of internal employees was a matter that was delegated to the CEO. However, the appointment of external candidate or PIC non-executive directors was a matter which was delegated to the Directors Affairs Committee of the board. So, but however, if there were agent appointments that require the CEO to sign off, those will be made by the CEO and then will then go to the DAC for ratification. Because sometimes there could be agents in appointing board members. We also had in place a directors database, which we kept at my office, of CVs of potential candidates that we could identify to be appointed to those investee companies, comprising of external candidates. Yeah. We also were doing it in line with the governance policy at the time, which I'm gonna touch on it briefly, on some of the aspects that it sought to address.
Why are you suggesting that it's better for it to be done by the Secretariat?
I'm not saying it's better to be done by the Secretariat, Commissioner.
What's your view? What did
I'm
you say about the
saying-
Secretariat?
Sorry?
What did you say about the Secretariat?
I'm saying, Commissioner, if you look at paragraph 182, I'm saying that this function was performed by the company secretariat team until the former CEO, through an EXCO resolution, took a decision to remove the function from the company secretariat and moved it to a position which he had included in the organizational structure of the executive head of investment management. I personally was not averse to such an EXCO decision because it is a management function.
So when you arrived there, it was already done.
When I arrived, it was something that was performed by my division, but then it was later moved to another division, which it's okay. It's a management function if you think about it. Yeah.
Okay, you don't want to see it come back to your division. I'm saying that because you say it's a management function anyway, or should be.
Well, it is a management function if you think about it, because although it's a function that has a lot of governance aspects to it, it's about appointment of boards to investee companies. Yeah. Yeah. So, where was I? 184. 5. Some of the initiatives that I presented to the DAC, and my presentation is there in Annexure 51, which will be 52, which I hope may assist this Commission of Inquiry, were the following. The integration of provisions of rotation of nominee directors, that is, the tenure shall not exceed 3 years and be subjected to annual review. I'm going to try to expand a little bit on this, Commissioner, because at the time there were also concerns that the tenure of some of the directors or non-executive directors that we have sent to those investee companies seem to have, been quite long, so they were not being rotated. So we're trying to introduce that aspect of rotation as well, which also, I think it also assists in terms of independence, because sometimes when a director has been sitting in a board of a company for quite some time, their independence tends to be questioned. Yeah. So that was an aspect that we're introducing. We also were introducing a qualitative measure of effectiveness of the board and individual nominee directors to achieve a desired outcome. And we wanted a 360-degree independent annual assessment to be done. So at the time when I came to the PIC, those were not done. And I felt that if those could be done, it will give a PIC a picture of whether the people that were sent to those boards were adding value in terms of what they were doing in those investees. And for us to assess that will be based on those assessments that the investee companies can share with the PIC. We also wanted the removal of a reference of a transitional period. At the time of my appointment, the prevailing policy still was having a transitional period, and this transitional period was on the issue of appointing a director to a listed investee company in South Africa. So one of the things to try and avoid competition laws and anti-competitive behavior, the recommendation was that we cannot appoint directors to investee company in listed entities where the primary listing is in South Africa. So when they were trying to do away with that, there was a transitional period, and I felt that the transitional period at the time before mine was a year, and I felt that, I mean, in 2017, I'm still sitting with that transitional period. I felt that we needed to do away with that transitional period and, you know, try to implement that, because there was a risk, there was a real risk of having to deal with competition issues. If, for instance, a director is sitting in a listed entity in South Africa where the competition commissioner may raise issues of competition laws, for instance, or insider trading. We were also talking about the issue of inclusion of sample disclosure and representation permission agreement as an annexure to the policy. So one of the things again was the issue of how do you deal with information when you are appointed to an investee company where at the same time you're an employee of the PIC? How do you deal with information that you get in your capacity as a director or as a non-executive director in an investee company? And we wanted to introduce a mechanism where the investee company and the PIC could then enter into that disclosure and representation permission agreement, so that when specific issues of information are to be disclosed, there is an agreement to that effect, so that those directors are not found wanting to have disclosed to the PIC information which they were not supposed to have disclosed. The removal of exceptions with respect to prohibition of non-executive directors and employees from serving on boards of investee companies in companies listed in SA. I've already talked about this. The inclusion of the criteria with respect to categories of employees who can serve on boards of investee companies based on different factors. That would have been the value of the investment, the strategic nature of the investment, and because one of the things here was, for instance, if you have a big investment in, I'm just going to give an example of an investment that is coming to mind now. In Kenya, for instance, where you have invested in Kenyan, what do you send a senior executive or do you send a junior executive? So those were some of the things that we wanted to, and you want to test the experience of that particular person that you are sending to that particular company, given the funding that you have provided, the strategic, nature of that particular investment for the PIC. So those were some of the things, and I hopefully it will assist this commission to come to a conclusion. And then I'm going to talk about the delegation of authority review process. During 2017, there was a process to review the delegation of authority, and Company Secretariat was responsible to ensure facilitation with all business units, and and to ensure that it is implemented. I'm going to add to that. There was a need to review the DOAs, as the last time that was done was 2015. Engagements were held with all relevant business units, and subsequent to that, all inputs from the business units and proposed changes to the corporate DOA and the investment DOAs were incorporated in the proposed DOAs. The proposed DOAs were submitted to respective PMCs and EXCO. EXCO made all the recommendations to submit to the board for approval via a round robin. The reason why it was done via a round robin, I believe it was submitted to EXCO on 2 different occasions, and there was a sense of feeling that there was delay in doing that. Hence, EXCO had to ultimately sign off a round robin resolution. So during the CISFIP meeting of the 23rd of August 2017, the proposed DOA for unlisted investments were submitted for recommendation to the board for approval. The committee did not approve the proposed DOA, as management was requested to do a write-up on the proposed changes and to provide reasons for the changes, which management undertook to do. After the CIS meeting, the CEO called me to his office and was very upset. He asked me who gave me permission to submit the proposed DOA. This gave an impression that I, on my own initiative, decided to submit the document. I was taken aback by this query, since EXCO had made recommendation to submit the revised DOAs to the board for approval, which the CEO himself signed off. After our brief meeting, I then wrote an email to him to clarify and also indicate my concern in terms of the process, and I've annexed that email, Commissioner. I'm going to talk about the incentives. the approval and annual salary adjustments for Tier 1 and 2 to management of the PIC for the financial year ending 31st March 2017, Annexure 53. The Minister wrote to the Chairman of the Board on the 6th of November 2017, raising issues regarding the process followed to obtain approval for incentives of Tier 1 and 2, and highlighted amongst others the following, and I'm going to quote from his letter. He said, the submission requested salary adjustment of average 33% increase with effect from 1 April 2017, but records shows that in 2015-16 financial year, PIC's executive directors and executive heads received salary adjustments of between 30% and 32% and will receive 7% increment in 2016-17 and 0% increase in 2017-18. And the submission did not have the relevant signature from the board chairman and the chairperson of the HR of the Human Resources and Remuneration Committee. The submission only has the CEO's signature, who also signed on behalf of the CEO. The minister then highlighted the communication protocol which is followed by all other entities under his portfolio when making submissions for his consideration, wherein submissions are submitted by the board chairperson through the company secretariat office to the minister. And then I've also attached that correspondence from the minister. I would like to implore to this commission, when making recommendation to make a determination on a centralized communication office between the shareholder and the PIC, I do also believe, Commissioner, that this is one area which also caused a lot of confusion at the PIC, where certain divisions will be communicating directly with the National Treasury. You know, I think there should be a central mechanism to communicate between the National Treasury and the PIC.
Just a question on paragraph 189. The salary increases of 33%, were this part of the restructuring program in 2015? Did they arise because of that?
Unfortunately, Commissioner, was not there when the restructuring happened. I believe so, from the communication from the minister. Yeah.
Yes, it would.
Because it referred to 15-16 financial year.
So it's quite likely that because of the changes of the structure, people then got more money.
Yes.
And you know, with different pens. Yeah.
Yes.
Okay.
Should I proceed? The whistleblowing and recommendations to this commission of inquiry. If the commission is so minded, I will urge it to make recommendations concerning the creation of a truly independent whistleblowing policy and procedure at the PIC. It was not ideal that the tensions which built up the conduct of the previous CEO and some board members found expression in the scurrilous allegations of James Nugu. But with channels for authorized whistleblowing blocked by a culture of victimization, the abuse of forensic investigations and legal processes, these symptoms are bound to emerge again. It is naive to assume that the political and other forces that sought to capture the PIC decision-making will simply desist in future. In that context, it needs to be made as easy, safe, and non-stigmatizing as possible for persons with knowledge of wrongdoing, even at a senior level, to bring this to the attention of the board, the shareholder, the executive, or a truly independent ombudsman. Currently, the PIC whistleblowing policy is inadequate and leaves a lot to be desired when it comes to disclosures about senior executives without such a whistleblower exposing themselves to the harrowing experiences I have undergone. The culture of reporting on ethical breaches is not embedded. The leakages of information is a classical example where employees are not free to report unethical conduct. Hence, the culture of complying without questioning the leadership for fear of victimization and persecution is prevalent at the PIC. Although there is a certain level of independence to the policy insofar as reporting is concerned, the policy also says that internal audit must then report to the CEO any whistleblowing matter that has come to their attention. The policy does not deal with with the fact that the CEO himself may be implicated. It therefore goes without saying that employees who wish to report corruption, irregularities, and impropriety against management will fear to do so. Hence, it is possible that employees may resort to other means. Ethics and ethical culture. The PIC requires an authentic ethics management function that operates in earnest, allowing employees to question and offer divergent views to those of management, whereby issues are debated instead of being imposed to employees by virtue of seniority. Not one that is there as a tick box exercise, but one which is functioning. The executive head of risk is the ethics officer in terms of the current ethics policy, and the function is not performed from an ethics management perspective. The ethics risk assessment remained an outstanding agenda item in the Social and Ethics Committee since 2016 until my suspension. The board should set the tone at the top and provide a clear strategic direction on the management of the company's ethics. But as authors Peter Ray et al. Suggest, corporate ethics cannot be reduced to compliance. One of the unintended and more unsettling consequences of a focus on ethics as a compliance issue, they say, is that ticking all the boxes creates the illusion of reducing risk without actually doing so. The term tone at the top has been in popular use ever since the corporate failures of the early 2000s, that is Enron, WorldCom, and the like. This led to the boards of directors to accept that they needed to lead by example by setting the right tone through their own behavior. But as management is charged with the responsibility for living by and overseeing the implementation of the code of ethics within the company, this was often where things came unstuck. Ultimately, according to the Greek philosopher Aristotle, moral virtue is learned, not inherited. And excellence is not an act, but a habit learned over time. Leaders are already teachers of their culture, whether they are aware of it or not. The truth is, unless the tone at the top is translated as the tone in the middle, implementation of ethics is unlikely to flow to lower levels in the company. And allow me, Commissioner, in my closing remarks to say a quote from an unknown author, which resonates profoundly with me. It says, "Your life has a purpose, your story is important, your dreams count, your voice matters, you were born to make an impact." I also want to thank the Commission for giving the PIC employees a platform to talk about their experiences at the PIC. Thank you.
You sound a bit emotional at the end there. Mr. Monahel, is there anything else?
Mr. Commissioner, may I just inquire whether members of the commission have questions for the witness? If there are no questions, that will be the evidence of the witness, and that concludes the business of the day.
I just have one question, which is just a bit different. If you go to paragraph 18, it's a simple question. Yeah, the first paragraphs. Paragraph 18 on James Nogu. We're back to James Nogu. The last line, if you can just read it for us. It starts, the PIC.
Okay,
making,
the PIC, the one that starts with, I refer to the author.
Yeah.
Okay. Or the PIC making disclosures or allegations of serious wrongdoing, albeit in a highly unorthodox and scathing manner.
Explain to me, why are you saying this? I mean, I also found those letters quite scathing, you know. So can you please explain why you find them scathing and unorthodox?
Okay, I'm going to say unorthodox because of course, it didn't follow the process which one would have expected it to follow, but then there were reasons given for that, why they didn't follow the processes that they were supposed to have followed in making those allegations. Scathing in the sense that, and I think again, it then warrants my view that it needed to be probed further. Because if you look at it, it was like it was touch and go. It was not detailed in terms of what exactly are the allegations. For instance, it talks about salary adjustments. It's not specific, you know, in terms of what salary adjustments, what process, what are the specific issues that relate to those allegations. So I feel it was a bit scathing, hence again my confirmation that it warranted an independent investigation.
Thank you. I think I'm done.
It's been a long day, Ms. Matebula. And I noticed that you didn't seem to be tiring. You were just carrying on. And for that, we are really, really grateful. Grateful for the time that you spent here. It's a long day indeed, I can feel it. And the courage that you have, that you've shown in coming to give evidence and give us all the information that you have done. It has gone into the issues that we are there to investigate, and for that we appreciate your efforts. Just one thing, or rather let me start off by, or end off by saying, it may well be that one of these days, before the end of the life of this commission, we might call you back to come and give more explanation or enlighten us on certain aspects. And I hope that you would still make yourself available if that were to happen.
I will make myself available,
You'll make
Commissioner.
yourself available. Thank you once again. With regard to, where was I looking? I think in paragraph 167 of your affidavit, you mentioned that you are considering the last sentence of that paragraph. I'm considering my legal options on the outcome of the disciplinary hearing and the consequent final written warning. Somewhere I think you are imploring us as well to deal with your disciplinary outcomes and so on. I must say, and you are talking about, monies that you expended that you'd like to be compensated on. Regrettably, we don't have a mandate or authority to order whoever to pay money and so on, but I would say to you what you say in paragraph 167, that's the right course to follow. That is considering your legal options in respect of that. We don't have the power to set aside the disciplinary committee's decision. We don't have that authority. What we may be able to say, we may be able to say something about it, but we can't set it aside. So your only option is what you refer to in paragraph 167. So thank you very much. For now, you are excused.
Thank you.
And you said that is the business for the day.
Yes, Mr. Commissioner.
Right, the commission will then adjourn until 10 o'clock tomorrow morning.